Great news, my friends. TPS has been extended for people from Haiti. In this video, I'll talk about the latest in immigration news and I'll talk about waivers. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, go ahead and like, share, and don't forget to comment below. Let's get right into it. What is going on in the immigration department? The latest great news, I'm just going to talk about one. The latest great news in immigration department is that our Secretary of Homeland Security, Mayorkas, has extended TPS for people from Haiti for about 18 months. Okay, and the way it works is that if you want to renew your TPS and you're actually from Haiti, or Haiti was your last country of residency, then you can renew it. And if you are a new eligible applicant, as long as you have been living in the US as of May 21st, 2021, you can apply for TPS. TPS is a temporary protected status. The benefit is just that you will be considered lawfully present in the US, and not to mention that you can apply for a travel document, and you can apply also for a work permit. The question now is whether you can have multiple applications with USCIS, and the answer is yes. If you have a asylum pending cases and then you want to apply for TPS and you wonder whether it's a good move, my friend, you should go ahead and apply if you can for TPS, because TPS is actually better in a way that you get the work permit within 6 months or 7 months, and you can get a travel document, because let's say that your asylum case is still pending and they haven't come up with a decision yet, but in the meantime TPS will be like a better option. But do not go ahead and cancel your asylum. Please do not do that. I will strongly advise you not to cancel your asylum case. And if you want to apply for your asylum and TPS at the same time, my friend, you can go ahead and do that. There's no penalty in doing so, as long as both applications are valid claim, not frivolous claims. Okay, so let's get into waivers. We have talked about waivers before. We have defined waivers, and we've talked about how can somebody be qualified for a waiver. In this video, I am just going to go over the chart, basically listing offenses and telling you whether there's a waiver available. And if you find it very interesting and you think that a waiver can be available for you, so you can be able to adjust status or apply for a new benefit, then please go ahead and contact me to 2751-2180. Email on display. Not today, it's Sunday, but tomorrow you can call, and then what's going to happen, if you email me, I'll email you back. But if you call, I'm going to text you back. Consultation fees is $175. So you know, I'll text you back requiring you to provide your full name, email address, so that we can send you a consultation agreement and a link to process payment. Once both are executed, then we can schedule you for a case assessment, so we will know whether you qualify for any waiver that will lead you to a path for adjustment of status. Okay, I've done okay too many times, but anyway, what is the first one? The first waivers, the way I'm going to talk about it, just list the type of offense and then say whether there's a waiver available for that. Okay, that's especially for immigrant visa, like somebody who wants to adjust status, apply for any immigrant visa, not like those tourist visa and stuff like that. Those want to have their special waivers if there is an offense there. Okay, so the first one, aliens previously removed. If you have been previously removed, is there a waiver for an immigrant visa? There is no waiver, but the DHS, Department of Homeland and Security, may grant permission to reapply for admission. And that's when you use the form I 212. So you ask them for permission to reapply if you have been previously removed. But there is a waiver for non-immigrant visa. Let's say that you want to come back in the US as a non-immigrant, like as a visitor or as a student. Yes, there's a waiver for that. You can apply for that waiver again. And additionally, you still have to apply for the I-212, which is the permission to reapply. Okay? So, alien unlawfully present. Is there a waiver? Yes, there is a waiver at the discretion. We have defined that before. I'm not going to go over that. But there is a waiver to waive unlawful presence. And we have two types. You can apply for the temporary waiving the unlawful presence using the form I-601A that requires you, once it is granted, to get outside of the US and come and then process visa at the consulate. But there's also a possibility to apply for the I-601 without going outside. Okay, that's for unlawful presence. Alien unlawfully present after previous immigration violation. So you've been unlawfully present again after you have violated any other immigration laws. The thing is, there's no waiver. However, DHS may grant permission to reapply, and under the permission to reapply, you're going to use the form I-2112. Excuse me. Alien present without admission or parole. So basically entry without inspection. Is there a waiver? It doesn't clearly say whether there is a waiver or not, but if you have been here without parole, there's an exception under the grandfather clause that says that if the petition was filed as of April 30th, 2001, they can waive that. If not, then you should consider just applying for a waiver and hope for the best. Failure to attend removal proceeding. Is there a waiver? No, there's no waiver if you fail to attend removal proceedings. However, the thing that's going to happen, you will be banned from basically adjusting status for 5 years if you fail to appear in removal proceedings, unless you provide good cause, the reason why you failed to appear in removal proceedings. Other than that, there's no waiver to waive that, but you have to go through the punishment, which is 5 years. It will prevent you from adjusting status for 5 full years, okay? Fraud and misrepresentation. Do we have waiver? Yes, we do have waiver. This is the waiver where you apply for the form I-601, and remember waiver, we've talked about it. You must have a qualifying relative and prove extreme hardship. There is a waiver for fraud and misrepresentation. False claim of US citizenship. There is no waiver available for that. But there is a waiver for people who are coming for non-immigrant visa, tourists, F1 visa, stuff like that. You can get a waiver. You can apply for it and hope that they give it to you. But as far as an immigrant visa, there's no waiver available for that. The only thing we do is look at the fact of the case, and if there's something that it's different from just like from the entire situation, we can ask for a waiver and basically put those facts into a better argument and say, we know that there's no waiver, but look at those facts. They're different from just those cases, you know, and then maybe they'll look at it and give you a waiver. But as far as just a regular waiver for that type of offense, there is no waiver. That's what I'm trying to say. And then we have smugglers. Yes, there's a waiver available at the sole discretion of DHS. Okay, but we know what waiver is. Must have qualifying relative and prove extreme hardship. if you're subject of civil penalty or final order under Section 274C for document counterfeiting, yes, there is a waiver available. Again, must prove extreme hardship and qualifying relative. Student visa abusers, so those people who actually violate student visa, there are no waiver available for that. Nothing, nada. So just try not to violate student visa unless you can come back again for try for another non-immigrant visa, another student visa, and apply for a waiver. But when it comes to adjusting status after violating student visa, pretty much abusing your student visa, there are no waiver available. Crime involving moral turpitude, we've talked about it. Yes, there's a waiver available for that. Again, waiver, as we said, it's basically qualifying relative, extreme hardship, and it is discretionary. Controlled substance violators, do we have a waiver for that? Yes, we have a waiver available for that. Okay, sorry. And then we have multiple crimes conviction. Waiver is available if activities for which the alien is inadmissible occur more than 15 years, okay, before the date of the alien application for adjustment of status. If you have multiple crimes, so the latest crime has to be like 15 years prior to you trying to apply for adjustment of status. Okay, and then we have controlled substance, no waiver available. Those are the things like drugs, really, if you involve in drug trafficking, human trafficking, there are no waiver available for that. Prostitution, yes, there is a waiver available for that. Okay, a certain alien involved in serious criminal activity who asserted immunity from prosecution. Yes, there's a waiver available for that as long as the crime occurred 15 years prior to your application for adjustment of status. Okay. Foreign government officials who have committed a particularly severe violation of religious freedom, no waiver available for that. No waiver available for that. Significant traffickers in person, like human trafficking, no waiver available for that. Okay. For inadmissibility based on diseases, it depends. It's basically the waiver is available for the spouse. Yeah, the waiver is available for that. There is a waiver. Let's just put it that way. There's a waiver, but we know waivers are discretionary. Failure to submit proof of vaccination. Well, there's no waiver for that, but still they're going to require you to actually submit that. You just have to go ahead and submit proof of vaccination. Come on. So physical, mental disorder, yes, there's a waiver available for that. That's pretty much about health. Drug abuser, no waiver available. When it comes to drug, no waiver is available. General prejudicial activities, espionage, sabotage, or prohibition, no waiver is available. Okay, terrorist activity, no waiver is available. Entry will have potentially serious adverse on foreign policy consequences, no waiver available, but inadmissibility applies to current situation. Okay. Membership of affiliation with communist or totalitarian, waiver are available. Participation in Nazi, like those people, genocide, and people who participate into the Nazi, like genocide, stuff like that, there is no waiver available for that. Association with terrorist organization, no waiver. Recruitment or use of child soldier, if you're recruiting children to be soldiers, there's no waiver for that. No. Public charge, no waiver is available for public charge on the ground of public charge. However, the applicant may overcome the funding by presenting evidence to convince them that they are admissible. So public charge is whether if they find that you are going to be a public charge, like depending on government, basically they're not going to admit you. You're not going to be eligible for a green card. However, you can challenge that and show them that you work and stuff like that. We can work on that. I've had a case like that before, and we were able to basically overcome it. Like basically put a motion to consideration, and it was granted because we can show that the person can actually work. He has done this and that. That's pretty much we can do. Okay, so sorry. Alien entering the United States to perform skilled or unskilled labor, no waiver available at the time of the visa. However, under IN, DHS may waive this inadmissibility. Okay. Permanently ineligible for citizenship immigrant, then there's no waiver available. Any alien who departed from or remained outside of the United States to avoid service in the armed force. So basically, you left the U.S. because you don't want to be part of the United States Armed Forces to be a soldier, and then you come back and want to adjust status, there is no waiver available for that. Practicing polygamy, there is no waiver available for that. International child abduction, no waiver, really. Unlawful voters, no waiver available. Former citizen who pretty much refused to renounce their U.S. citizenship because they didn't want to pay taxes, there's no waiver available for that. So the list goes on and on. I think the next time what we're going to do is basically do a PowerPoint presentation and just put all those offenses there. But I'm not sure when we're going to do that. I'm not into the rush of doing it. But what I might tell you is that really if you have an offense and preventing you from adjusting status, you have to find out whether there is a waiver available. And if there is a waiver that is available, that's when we can see if you have a qualifying relative and how we can prove extreme hardship so that we can help you out adjust status. So that's what we do. If you want to come for consultation, please call me in advance and we can schedule that in-person consultation. Consultation fees apply as usual. That's it for today. I really wanted to tell you that there is hope with those waivers. If we can put a better argument, we have seen people getting their offenses waived and they were able to adjust status. Okay, but some offenses are just not waivable, that's it. But they are waivable in a way that you can get a non-immigrant visa or status. But as far as adjusting status for a green card, that's when those type of offenses are not waivable. And that's it for today. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. This was U.S. immigration, and this was too long because we had to cite a couple offenses. We didn't even finish the list. but I had to cut it short because really, if you need consultation, just do it, because it's going to help you clarify where you stand. That's it. Until next time, bye-bye.